I'll print the exhibits out.
Right here. Right here.
They don't X them out because it's set for sentencing, so I can still print out stuff from next week. Well, once it's taken care of, they remove the discovery.
Good grief, I just wrote 2023. I was writing 2028? Great. At least I'm making us younger, not older. What is this? Hers.
I'm going to take care of it, Mr. Mayor.
All right, ma'am. Good morning. Are you Melissa Taylor?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each?
This is where most people don't realize how serious court really is before guilt. Before punishment, the judge has to answer one question: is this person legally able to stand here right now? No competensino case. Everything pauses until that box is checked.
Case.
So waived.
I'm going to take judicial notice of the court's file. Ms. Taylor was evaluated for competency to stand trial. Dr. Kapan did that evaluation. I've received the report dated May 22nd of 2025 with the finding from Dr. Kapan that Ms. Taylor is currently competent to stand trial. Is there any other evidence with regard to competency?
Your Honor, I can only say that I've visited with her a couple of times out at the jail and again this morning, and I believe that she's mentally competent.
All right.
I can't say that there's no evidence of mental incompetency because I think that there was at one time the evidence, but there's been none that I've observed that would lead me to think that she's currently mentally incompetent.
All right. And Mr. Nichols?
Nothing to add, Your Honor.
All right, then, based on the report and Mr. Kimler's comments, I am going to find Ms. Taylor currently competent to stand trial. Now,
That ruling changes everything. Competent means the system can move forward at full speed, no delays, no treatment detours, just straight into the legal fire. One sentence, just turn the pressure all the way up.
Ms. Taylor, in cause number 24 DCCR 2177, you're charged with second-degree felony offense of assault on a peace officer from October 2nd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
That would be correct, yes.
All right, and in cause number 24, DCCR 2311, you're charged with the state jail felony offense of credit or debit card abuse from October 2nd of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and...
This is rare back-to-back guilty pleas with no hesitation, but hey race, the hidden cost. Every guilty shuts another legal door behind her. No jurino, appeal safety net, just consequences. Would you take that risk?
voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
I did.
Do you fully understand them?
Yes, ma'am, I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a cap of 5 years in the assault on a peace officer case. And then whatever happens, I guess you're pleading open on the other one as long as I run them concurrently.
I made a recommendation for 12 months on that
Okay,
case, Your
12.
Honor, and the defense had made a recommendation for probation concurrent with the one day.
Okay, so in essence, a cap of 12 months then? Would
Yes,
that,
Your Honor, that's fair to say.
Yeah, concurrent.
with everyone's permission,
Yes,
can I make that?
So your limit, your 12 months and 5 years.
Well, that's 5 years.
Let's see.
But
Cap. So it would be a cap of 12 months on that state jail case. Do you understand?
Yes, ma'am. And that's for
Or with a building.
No, it's
No, it's for a credit
I'm sorry,
card.
credit card.
Yeah.
So what that means is that if we go forward this way, you're leaving your punishment up to me.
Okay.
And as long as I don't give you more than 5 years in the assault on a peace officer case and 12 months on the credit debit card abuse case, then you're waiving your right to appeal. I can give you 5 years, I can give you less. It'll all be determined when I get the information at a sentencing hearing. You have an absolute right to have a jury come in.
This might sound routine, but it's massive. Waiving a jury means 12 people are out and one judge decides everything. Some defendants think it's simpler, others realize too late it's also riskier.
To determine two things. The first would be to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to them. If we go forward this way, you're waiving that right and leaving it up to me with those ranges that you've agreed to. Is that what you want to do?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1 in each case.
Without objection.
It's admitted in each case. All right, ma'am, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Again, find that you're mentally competent and understand the nature and the consequences of your pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we will cut back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Kimler. He'll present it to me on your behalf when we come back. All
Your
right?
Honor, I do have a support letter that I tendered to the court.
If you'll just get that to the clerk, please. All right. Thank you, ma'am. You can go back with the bailiff. Exactly when both of y'all do better. When she does it, I think of that all the time. All right, sir, you said Dog Wilson? Ma'am, I'm sorry. I was looking at the, down this way and not at you.
Seidel Wilson?
Seidel?
Yes, ma'am.
Okay. And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Let's see. I'm getting there. All right, Ms. Wilson, in cause number 22-40450, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation February 27th of 2024 for the offense of burglary of a habitation, and that was a 5-year deferred probation. Is that correct?
Yes, Your Honor.
And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department March 14th, March 26th, April 9th, April 23rd, May 8th, and May 22nd, June 4th, and June 18th of 2024. And is that true or not true?
Yes, Your Honor.
Is it true? Okay. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
Yes, Your Honor.
Judge, since we have an agreement.
Listen, hold on.
I'm sorry.
Thank you.
Since we have an agreement, we could drop 3, 4, 5, and 6, and just go to 7, if that's all right with the court.
Count 7 alleges that you were arrested for the offense of failure to identify a fugitive from justice and giving false information April 14th of 2025. And is that true or not true?
True.
Count 8 alleges that you were arrested for possession of drug paraphernalia April 14th of 2025. And is that true or not true?
True.
And then count 9 alleges that you were at a location other than your residence at approximately 12:32 a.m. April 14th of 2025. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 7, 8, and 9 freely and voluntarily?
True.
Was they volunteer?
Volunteered.
And did you, it's okay.
Yes, Your Honor.
It's all right.
Sorry.
You're good.
Thank you.
Did you enter those pleas of true freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, Your Honor.
And do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Ms. Wilson is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1, 2, 7, 8, and 9 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you in accordance with your agreement to a term of 3 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence.
Notice how the judge keeps repeating the same questions. That's not impatience, that's protection. These answers lock the record tight so no one can later claim confusion, pressure, or misunderstanding.
For any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas.
Yes, Your Honor.
Good luck to you, ma'am.
Thank you, Your Honor.
This is the reality of probation violations. Miss appointments pick up new charges and the system snaps shut fast. 3 years decided in minutes. Do you think this sentence was fair, or should mercy have played a role?